So the Supreme Court will now hear arguments in the next big Second Amendment case, and it once again deals with state concealed carry restrictions and laws passed in direct defiance to what the court already said in their 6-3 ruling in a case called New York State Rifle and Pistol Association versus Bruin. So let's talk about what is happening in this critical challenge and what is likely going to be the next big Second Amendment case. Now, before we jump into this video, if you guys want to support the channel, one of the best ways to do that is simply subscribing to the channel. Also double check to make sure YouTube is not unsubscribed you, because they love to do that, especially on two-way channels. And I also want to thank one of the main supporters of this channel, which is First Form. You guys know that First Form is an amazing company. Their culture is unmatched. It bleeds into everything that they do, but also they have amazing supplements. I love their protein powder, their pre-workout. I even really enjoy their energy drinks. So if you guys are interested, check them out using the links down below. And if you order something $100 or more, you can get free shipping on that order. And also they have a money back guarantee on any order. So as I mentioned in the intro, recently the Supreme Court granted review to a concealed carry restriction case called Woolford versus Lopez. This is a huge case and it's significant for everyone in states like New York, New Jersey, California, Hawaii, and others who are currently living under laws which attempt to ban concealed carry even after the Supreme Court's recent ruling in Bruin. The Hawaii Woolford versus Lopez case sought emergency Supreme Court intervention, which surprisingly was granted review by the Supreme Court. This challenge revolves around a preliminary injunction and the Ninth Circuit finding that states and their catch-all public property bans on concealed carry is permissible under the Second Amendment. Recently, to the surprise of many, the DOJ and AG Bondi actually stepped up in support of this challenge, and they called on the state bans like these ones to be struck down as a violation of the Second Amendment. Well, that appears to have actually paid off, and the Supreme Court, in a very surprising turn of events, decided to grant emergency review to this case. This grant of cert breaks the Supreme Court's track record of turning away almost every emergency or interlocutory case when it involves the Second Amendment. And now the Supreme Court has set oral arguments to take place in this case, and it's going to happen at the beginning of next year on January 20th. So this is great news, and again, this is going to be the next big two-way case that is ruled on by the Supreme Court. Now, if you're not aware, the Woolford case is a challenge to Hawaii's new laws on concealed carry that they passed in direct defiance to what the court already said in Bruin. This law, like others, tried to add more restrictions on concealed carry and create a default rule where individuals can carry firearms at private property that's open to the public only if the owner of that property provides express permission to do so. Plaintiffs, along with two-way organizations, sued the state of Hawaii to strike down this law, and on review, the lower court granted them a temporary restraining order, also known as a TRO, which was later converted to a preliminary injunction. Simply, both of those were a way to just temporarily halt the enforcement of the law. Of course, the state of Hawaii did not like that, so they appealed to the Ninth Circuit Court of Appeals, and that also was reviewed along with the California carry ban, which is a very similar law. And on review, the Ninth Circuit upheld the catch-all property ban in the state of Hawaii and reversed the injunction issued by the district court. Now, after that, the plaintiffs asked for the Ninth Circuit en banc panel to take review of this case, but that was rejected by the Ninth Circuit en banc panel, which in many ways wasn't necessarily surprising because the Ninth Circuit always loves to rule in a way that upholds these type of two-way restrictions. That led this case to seek emergency Supreme Court intervention by the court. Now, this case had a hard road to get Supreme Court review since it's still at a preliminary injunction stage, which means it has not reached the final merits of the case. And the Supreme Court has traditionally denied review to these type of interlocutory emergency cases. However, with the United States DOJ in support of this cert request, the Supreme Court actually broke their tradition and granted review to this emergency case. That is likely because of the concessions also made by the state of Hawaii in the Ninth Circuit, and because of the trap that the plaintiffs actually caught the state of Hawaii in based on what they argued at the lower court levels. In the recent amicus briefs filed by the United States government, they stated that the near complete ban is flatly inconsistent with Bruin and the long history underlying it. Bruin recognized that an ordinary, law-abiding citizen has a general right to publicly carry arms for self-defense. They pointed out that Hawaii in the Ninth Circuit argued that there was nothing else for the lower court to develop at the trial court level and no further evidence that was actually needed at the lower court level. So they argued to the Ninth Circuit that this did not need to be sent back down. And so this is pointed out by the Trump DOJ when they were seeking Supreme Court review, because ultimately what Hawaii was also trying to do was push the Supreme Court to deny review to this case to kick the can down the road and say that you need to send this back down to the lower court for further development of the record. But actually, at the Ninth Circuit level, they argued that none of that was needed. And that was kind of a interesting trap that Hawaii caught themselves in and got stuck in because of the arguments that they made at the lower court level. But ultimately, the Supreme Court disagreed with the state of Hawaii, and the Supreme Court granted review to the case. Now, the Supreme Court cert states that it is granted as to question 1 that was presented in the petition. So what is the question that was presented? What was the question 1 in the cert petition? Well, the question was whether the Ninth Circuit erred in holding in direct conflict with the Second Circuit that Hawaii may presumptively prohibit the carry of handguns by licensed concealed carry permit holders on private property open to the public unless the property owner affirmatively gives express permission to the handgun carrier. That means that the Supreme Court will directly address the catch-all property bans that were passed in direct defiance to the Bruin ruling. It's also very likely that this decision will dig deeper into the prior Bruin holding and outline a little bit more and develop a little bit more how Bruin should be applied after that ruling and how should lower courts use this type of two-way analysis going forward. Now, since the grant of review by the Supreme Court, a couple things have developed. First, there have already been motions filed to hold some of these other concealed carry litigations that are going on in the lower courts, and essentially there are motions to hold them until the Supreme Court rules in the Wolford case. However, there is also one other challenge, I believe, in New Jersey dealing with concealed carry bans, similar, laws that were passed post-Bruin, which is actually asking for the en banc panel in the Third Circuit to not hold that case. Instead, they argue that that issue should move forward, that it's a very important case, and also that maybe it will not be directly impacted by Wolford and some of the rationales in Wolford, and therefore they're pushing for en banc panel review. The second thing that is developing is we are already hearing rumblings that some of these states may try to moot the catch-all property bans that they put in place. Maybe California, New York, New Jersey will try to remove those or modify those statutes so that the Supreme Court holding in this Wolford case dealing with the Hawaii law will not directly impact these state laws that other states have passed. So we will be keeping our eyes on these states to see if they attempt to skirt the impact of the Supreme Court case by removing or modifying these so-called vampire rules. But for right now, the Supreme Court has set this case for oral arguments early next year. Again, that's going to happen in kind of late January, but this will actually be ruled on before the end of their term. So at the latest, we would know by mid next year, June, July, usually end of June, what the Supreme Court is going to rule on this critical two-way issue. So this is huge for the Second Amendment movement going forward, and the Supreme Court once again will hear a critical Second Amendment case dealing with concealed carry restrictions, and we're going to have to wait to see, how does it develop, and now we're going to wait for the briefs of both sides to be submitted by the Supreme Court, and also likely a ton of amicus briefs. So as we get more information, as it develops more, I will let you guys know. So if you guys like this video and you would like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. All those things help to fuel the algorithm. Also, if you're interested, you can check out one of these two videos here on the screen that the YouTube algorithm thinks that you will find helpful. But as always, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.